A federal judge just delivered a devastating blow to President Trump. For the third time in weeks, a court has permanently blocked key provisions of his election executive order, ruling the president has no constitutional authority to rewrite election laws. This isn't some minor procedural setback or a temporary restraining order that might get overturned. This is a permanent injunction that declares what constitutional scholars have been saying for months. The president exceeded his authority and violated the separation of powers enshrined by the founders themselves. When 3 different federal judges in 3 different jurisdictions all reach the same conclusion, you know something fundamental has just cracked in this administration's legal strategy. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what set off this unprecedented legal defeat? On March 25, 2025, Trump signed Executive Order 18248, a sweeping directive that attempted to force states to require documentary proof of citizenship for voter registration, ban the counting of any ballot received after Election Day, and strip federal election funding from states that refused to comply. Legal experts immediately called it unconstitutional. Multiple states filed lawsuits within days, and now, as of January 13, 2026, 3 separate federal courts have ruled against the administration. This isn't just another political controversy or routine legal dispute. Members of both parties in Congress are watching the judiciary systematically dismantle what critics are calling the most aggressive executive overreach on elections in modern American history. And believe me, when even Trump-appointed judges are questioning the legal basis for these orders, you know something enormous has just detonated. Here's the full picture of what's been unfolding. Tensions between the Trump administration and the federal judiciary have been simmering for months, fueled by over 200 lawsuits challenging executive actions and repeated clashes over constitutional boundaries. But everything escalated on January 10, 2026, when District Judge John H. Chun in Seattle issued a permanent injunction in favor of Washington and Oregon, 2 states that conduct their elections almost entirely by mail. The ruling was unusually blunt. Judge Chun, appointed by President Biden, found that the executive order violated the Constitution by attempting to concentrate election power in the presidency, something the founders deliberately prevented. This wasn't about policy preferences or partisan disagreements. It was about fundamental constitutional limits on presidential power. Smash that like button if this is making sense so far. Here's where it really gets serious. When legal scholars reviewed the January 10th ruling, they recognized immediately that Judge Chun had crossed a threshold rarely seen in modern jurisprudence. He didn't just pause the order temporarily, he issued a permanent injunction, a final determination that the president's actions were unlawful. And let's be honest for a moment, permanent injunctions against sitting presidents are extremely rare. They don't happen over policy disputes or political disagreements. They happen when courts find a president has fundamentally violated constitutional boundaries. Here's what multiple sources say happened next. On January 10th, Washington Attorney General Nick Brown announced the ruling with language that stunned observers. Quote, "Today's ruling is a huge victory for voters in Washington and Oregon and for the rule of law. The court enforced the long-standing constitutional rule that only states and Congress can regulate elections, not the election denier-in-chief." Oregon Attorney General Dan Rayfield followed with his own statement declaring, "This is a win for Oregon voters and a defeat for President Trump's effort to interfere in our elections. Thanks to today's ruling, Oregonians can register to vote and have their ballot counted without fear that the president's made-up rules will stop them from voting." The ruling detailed exactly which provisions were struck down. First, the requirement for documentary proof of citizenship to register to vote. Second, the mandate that all mail ballots must be received by Election Day to be counted. Third, the provision tying federal election funding to compliance with these new rules. Judge Chun found that each of these exceeded the president's constitutional authority. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. When the full text of Judge Chun's opinion was released, legal analysts noted something extraordinary. The judge didn't just rule against Trump on procedural grounds. He issued a constitutional rebuke that could echo through future presidencies. Quote from the ruling, "In the framework of our Constitution, the president's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker." He continued, "Separation of powers was designed to implement a fundamental insight. Concentration of power in the hands of a single branch is a threat to liberty." That's when it became clear this isn't just another legal setback. The bombshell moment came when Judge Chun explicitly stated his decision's purpose. In granting this relief, the court seeks to restore the proper balance of power among the executive branch, the states, and Congress envisioned by the framers. Those words sent shockwaves through Washington. When a federal judge frames his ruling as a constitutional restoration, as correcting an imbalance of power, it signals something far more significant than a typical adverse ruling. It signals that the court views the president's actions as a fundamental threat to democratic governance. This move sent shockwaves through Republican leadership. When three separate federal judges, including some considering the same legal questions, all reached the same constitutional conclusion, the claims of judicial bias or political persecution collapse entirely. This isn't the first time a president has faced judicial pushback on elections. Think back to the 2000 election in Bush versus Gore. The Supreme Court intervened in a contested election, but even then, the court wasn't ruling that a president had exceeded his constitutional authority. That was a ruling about how to count votes in a single state's recount, not whether a president could unilaterally change election rules across the entire country. The legal questions were fundamentally different, and the constitutional stakes, while significant, didn't involve the same direct confrontation with separation of powers. Then there was Nixon and Watergate. While Nixon faced multiple legal challenges, none directly challenged his authority to regulate how Americans vote. The constitutional boundaries at stake there were different, relating to obstruction of justice, abuse of executive power in criminal investigations, and ultimately the president's amenability to judicial process. Nixon's famous response to the Supreme Court's ruling in United States versus Nixon, ordering him to turn over the White House tapes, was compliance. He turned over the materials. The system worked because even a president under siege respected judicial authority. What's happening now represents something fundamentally different. This administration isn't backing down in response to adverse rulings. It's planning appeals, preparing new executive orders, and attacking the judges who rule against it. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the legal battles during Trump's first term, including challenges to his travel ban and various executive orders. Some of those orders were blocked, some were upheld. But what's different now is the scale and consistency. According to Just Security's litigation tracker, as of January 2026, there have been over 200 legal wins for plaintiffs challenging Trump administration actions. Government actions have been permanently blocked in 51 cases, temporarily blocked in over 100 more. The pattern is clear. When presidents push constitutional limits this aggressively, even a judiciary they help shape eventually reaches a breaking point. So, what allegedly triggered this unprecedented judicial response? According to legal experts who reviewed the March 2025 executive order, the actions violated bedrock principles of constitutional governance. The order attempted to impose proof of citizenship requirements that would require millions of Americans to produce documents like passports to register to vote. It sought to ban the counting of ballots postmarked by Election Day but received after, which would disenfranchise hundreds of thousands of voters in states like Washington, where over 300,000 ballots arrived after Election Day in 2024 alone. Here's the kicker. The Constitution explicitly grants states and Congress, not the president, authority over election rules. Judge Chun wrote, "Whenever the president issues an executive order, the power to issue the order must stem either from an act of Congress or from the Constitution itself. If the president lacks a statutory or constitutional basis, the act is unlawful." Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one executive order or one election cycle. If a president can unilaterally impose citizenship documentation requirements, dictate how states count ballots, and punish states that don't comply by withholding federal funds, the entire framework of federalism collapses. State control over their own elections becomes meaningless. Once that precedent is set, there's no turning back. This puts Republicans in Congress in a nearly impossible position. On one side, they face pressure from a base that has been told repeatedly that election security requires these exact measures. That means defending the executive order regardless of what courts say, attacking the judiciary as politically motivated, and framing the entire situation as proof that the system is rigged against conservatives. On the other side, they are forced to reckon with rulings that cite the Constitution's text, the founders' intent, and over 200 years of precedent. They now have to explain to their constituents why a president should be able to do what Congress explicitly cannot. And here's the tricky part. There's no credible defense. Either the constitutional analysis in 3 separate court rulings is wrong, which would require believing that multiple federal judges, including those appointed by presidents of both parties, are all misreading the same constitutional provisions, or the executive order genuinely exceeded presidential authority, in which case the administration's position is indefensible. Legal and political analysts are calling this a constitutional crisis unfolding in slow motion. Derek Klinger, a senior staff attorney with the University of Wisconsin Law School's State Democracy Research Initiative, told VoteBeat, "The court is very clear that the Constitution gives no authority to the president to do any of these things, and that federal law doesn't either." Do me a favor and slam that like button because it genuinely helps this video reach more people. Even David Becker, an election lawyer who worked in the Justice Department's Civil Rights Division and now leads the nonprofit Center for Election Innovation and Research, acknowledged that the legal trajectory is devastating. Quote, "It keeps getting worse for him. The more courts look at this executive order, the more they come to the conclusion that the president vastly exceeded his constitutional authority." Justin Levitt, an election law professor at Loyola Marymount University who advised President Biden's administration on democracy and voting rights, said Trump's election agenda boils down to project power that he doesn't have, in hopes that the public will lose confidence in election results even if the rules don't change. So let's break down what this could mean. First, the political impact is immediate and devastating. 3 federal courts have now ruled that the president has no authority to impose these election requirements. While the administration is expected to appeal, election law experts told VoteBeat the president faces long odds. The constitutional text is unambiguous, and the courts have been unanimous in their analysis. This creates a perception problem that no amount of political spin can overcome. When 3 judges all say the same thing about constitutional limits, the argument that courts are simply biased becomes impossible to sustain. Second, it creates a massive problem for the 2026 midterm elections. Every Republican candidate will face questions about whether they support a president whose election policies have been repeatedly struck down as unconstitutional. Campaign ads are already being drafted featuring the judge's most damning quotes about constitutional overreach. Democratic challengers in swing districts are already pivoting their messaging to focus on rule of law, constitutional governance, and the administration's repeated legal defeats. A poll conducted by the Associated Press found that 62% of Americans believe the president should follow court orders, even when he disagrees with them. That creates a significant political vulnerability for any candidate seen as defending unconstitutional executive action. Third, this ruling sends a message to state election officials nationwide. Washington Secretary of State Steve Hobbs noted that the ruling protects the ability of state officials to run their elections according to state law, not presidential preference. Quote, "This ruling is a victory for Washington voters and the rule of law. It draws a firm line between enforcing the law and trying to remake it, and it protects voters and local election officials from political overreach that would have made our elections less fair, not more secure." Finally, looking ahead, the broader implications are profound. The White House has announced plans for a second executive order on elections, but federal court rulings show the approach has fundamental limitations. The administration has also pushed for congressional action to change federal election laws, but federal legislation has stalled in a divided Congress. Some states, including Ohio, have responded to Trump's pressure by changing their own laws, including repealing grace periods for mail ballots postmarked by Election Day but received afterward. But the federal executive order itself remains legally dead, and any future executive action on elections will face immediate legal challenge with 3 precedential rulings already establishing that presidential authority over election rules is virtually non-existent. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political fallout, this is really about fundamental constitutional principles. The Constitution deliberately divided power over elections between states and Congress. It gave the president no direct role in setting election rules. The founders understood that concentrating election control in one person's hands was inherently dangerous to liberty. Judge Chun quoted that exact concern in his ruling. If a president can dictate who votes and how votes are counted, democratic accountability becomes meaningless. This scenario is causing sheer panic within Republican legal circles. Reports indicate that administration lawyers held emergency consultations to determine how to respond. Some argued for an aggressive appeal that challenges the entire constitutional framework of federal court oversight. Others insisted that the legal arguments are simply too weak, that continuing to litigate on these grounds only produces more damaging precedent. Meanwhile, conservative legal scholars are expressing frustration. They see the administration's approach as legally reckless, likely to produce court opinions that constrain future Republican presidents for decades. Things escalated further when Trump himself responded. He called the rulings politically motivated and suggested the judges were biased against his administration. He claimed the executive order simply enforced existing laws, despite 3 courts ruling that it actually attempted to create new ones. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more extraordinary. The administration's defensive response essentially confirms the weakness of its legal position. Instead of addressing the constitutional arguments directly, the reaction was deflection and attacks on the judiciary. When your defense is attacking those interpreting the Constitution rather than disputing their interpretation, you've already lost the argument. Legal experts immediately flagged the problem. Attacking federal judges for exercising their constitutional duty to review executive actions while claiming the executive actions are legally sound creates a contradictory dynamic. If the legal position were strong, the administration would be disputing the constitutional analysis, not the motives of the judges making it. This goes far beyond one executive order. It's about whether a president can use executive power to reshape how Americans vote without congressional authorization. If there are no consequences for allegedly exceeding constitutional authority on elections, it signals that the separation of powers is merely advisory. It's not just about this administration. It's about whether the constitutional framework that limits presidential power has any teeth. Future presidents, regardless of party, will look at this moment and calibrate their own willingness to push constitutional limits accordingly. The founders were explicit about this. They understood that elections were the mechanism by which the people held the government accountable. They deliberately denied the executive branch direct control over election rules because concentrating that power in the hands of one person, the person most incentivized to manipulate election outcomes, was the definition of constitutional malpractice. Madison wrote about this in Federalist 51, explaining why divided government was essential to liberty. The entire architecture of American constitutional governance assumes that no single branch can dominate the others. If this blows your mind, hit that like button right now. Here's the situation. 3 federal judges have now ruled that President Trump's election executive order exceeds his constitutional authority. Permanent injunctions are in place in multiple jurisdictions. The administration is expected to appeal, but legal experts say the constitutional arguments are overwhelming. This is no longer just a legal dispute. It's about whether the American system of divided powers can survive a president determined to centralize control over elections. When 3 federal judges in 3 different courts all reach the same constitutional conclusion, we've entered genuinely unprecedented territory. If there are no consequences, it sets a dangerous precedent. Future presidents of any party could attempt to dictate election rules by executive fiat, knowing that even if courts strike them down, the political damage to opponents will already be done. Keep a close eye on this story. The administration is preparing appeals. More states are joining the legal challenges. The Supreme Court may ultimately weigh in, though its previous rulings limiting nationwide injunctions have already shaped this litigation, and voters across the country are watching closely to see whether their elected representatives will defend constitutional limits or abandon them for partisan advantage. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 3 federal courts have now permanently blocked key provisions of President Trump's election executive order. Attorneys general from both blue and red states have joined challenges. Legal experts across the political spectrum have called the executive order unconstitutional. The administration is expected to appeal, but the constitutional arguments appear overwhelming. The Justice Department has signaled it will continue fighting. The appeals could reach the First Circuit and eventually the Supreme Court. But the High Court's previous rulings on executive authority, including its June 2025 decision limiting nationwide injunctions, haven't helped the administration on the substantive constitutional questions. Courts have found ways to block the order anyway, using class action certifications and narrowly tailored injunctions that provide complete relief to affected parties. Meanwhile, the clock is ticking toward the 2026 midterms. Every day that passes without a legal victory for the administration is another day that state election officials can continue running their elections under existing law. Washington, Oregon, and the other states that have secured rulings will hold their primaries and general elections without the citizenship documentation requirements, without the ballot receipt deadlines, and without the funding conditions the executive order tried to impose. This isn't just another news cycle that will fade away. This is a constitutional confrontation unfolding in real time. What happens next could determine whether the separation of powers, the fundamental structure that limits presidential authority, has any meaningful force when a president is determined to test it. The evidence is out there. The rulings have been issued. The constitutional analysis has been published in 3 detailed judicial opinions that future courts will cite for decades. Now we wait to see if constitutional accountability still holds any weight in American democracy, or whether executive ambition can simply outlast judicial resistance. The stakes have never been higher, the constitutional violations have never been more clearly documented by the judiciary, and the confrontation between executive ambition and constitutional limits has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.